Supreme Court, in the matter of AEJAZ Ahmad Sheikh versus State of Uttar Pradesh, dismissed the appeals and said that when an appeal against conviction is preferred before High Court, at the earliest stage, the High Court must examine whether there is a proper statement of accused recorded under Section 313 of CrPC or Section 351 of the Bharatiya Nagrik Suraksha Sanhita 2023. If any defect is found at the stage, the same can be cured either by High Court recording further statement or by directing the trial court to record. If this approach is adopted, argument of delay and prejudice will not be available to the accused. There are several criminal appeals which come to Supreme Court where we find that vital prosecution evidence is not put to the accused in statement under section 313 of the CrPC, said Supreme Court. The court becomes helpless as due to long lapse of time, defect cannot be cured by passing an order of remand. In the case of Rajkumar versus State National Capital Territory of Delhi, the court dealt with this issue. It said, in many criminal trials, a large number of witnesses are examined and evidence is voluminous. It is true that judicial officers have to understand importance of section 313, but now the court is empowered to take the help of prosecutor and the defense counsel in preparing relevant questions. Therefore, when trial judge prepares questions to be put to accused under section 313, before putting the questions to the accused, judge can always provide copies of the said questions to learned public prosecutor as well as learned defense counsel and seek their assistance for ensuring that every relevant material circumstance appearing against the accused is put to him. When the judge seeks assistance of a prosecutor and the defense lawyer, lawyers must act as officers of the court and not as mouthpieces of their respective clients. While recording the statement under section 313 of CrPC in cases involving large number of prosecution witnesses, judicial officers will be well advised to take benefit of subsection 5 of section 313 CrPC, which will ensure that chances of committing errors and omissions are minimized. In 1951, while delivering verdict in the Tara Singh versus State case, the court lamented that in many cases, scant attention is paid to salutary provision of section 342 CrPC 1898. We are sorry to note that the situation continues to be the same after 72 years as we see such defaults in large number of cases. The national and state judicial academies must take a note of this situation. The registry shall forward a copy of this decision to national and all the state judicial academies. These appeals arose from the same impugned judgment of High Court by which one Hasim Sheikh, the accused, was acquitted of offence punishable under section 302 of IPC. The incident was very gruesome. It was the death of Amina, wife of accused, and her three daughters, namely Najma, Fatima, and Salma, due to burn injuries. Even Aslam, cousin of accused, died due to burn injuries sustained in the same incident. Court said that the prosecution has heavily relied upon dying declarations of the two victims. As evidence was not put to accused in statement under section 313 of CrPC, he was denied an opportunity to explain the same. Hence, omission causes prejudice to him. Therefore, evidence of dying declaration will have to be kept out of consideration in this case. This incident occurred on 26 December 2008. Even assuming that omission in recording statement of accused is curable, question is whether, after a lapse of more than 14 years, the case can be remanded to trial court for further examination of accused under section 313 of CrPC. After such a long gap of 14 years, it will be unjust to compel accused to face such an examination. Accused has undergone incarceration for more than 6 years. From date of trial court judgment till date of impugned judgment, there was hanging sword over him of capital punishment. Therefore, court said that we are of view that it will be unjust now at this stage to pass order of remand for recording further statements under section 313 of CrPC. Remand at this stage will cause prejudice to accused. Though we do not agree with some of findings recorded by High Court, it is not possible to find fault with ultimate conclusion drawn by it. There are two other important aspects of this case. Co-accused Aslam, cousin of accused, also suffered burned injuries in the incident. He died on 2nd January 2009 with septicemia. He suffered 40% burn injuries. According to prosecution's case, after pouring kerosene oil on victims, accused and Aslam were standing outside the room and were not allowing anybody to enter the room. Co-accused Aslam himself was victim of fire. There was no explanation offered by prosecution of how accused and Aslam suffered burn injuries. These burn injuries to Aslam proved to be fatal. They also raised suspicion about prosecution's case. Court said that we are dealing with an appeal against acquittal. After reappreciation of the evidence, we find that the view taken by High Court that guilt of accused was not proved beyond a reasonable doubt is possible view, which could have been taken on basis of evidence on record. Even assuming another view is possible, there is no ground to overturn the order of the acquittal.